Yes, be ready. Start. In an important ruling concerning the principle of restitution under section 144 of the Code of Civil Procedure 1908 within bracket CPC, the Supreme Court observed that if after knowing that the decree was liable to be reversed, a stranger auction purchaser bracket start not being party to the proceedings bracket close purchases the property in execution of the decree, then he could not claim the protection of being a bona fide purchaser, and the principle of restitution would apply in such circumstances. Stop. Reversing the findings of the High Court, the bench comprising Justices Hrishikesh and Prashant Kumar Mishra observed that if the person who has purchased the suit property from the decree holder despite having full knowledge of pending appeal proceedings against the decree, then the purchaser of the suit property from the decree holder is not entitled to object restitution on the ground that he is a bona fide purchaser. Stop. The judgment authored by Justice Prashant Mishra drew its strength from the case of Chinamal and others versus and AIR 1990 SC 1828, where the court distinguished between the decree holder who purchased the property in execution of his own decree, which is afterward modified or reversed, and a person who is not a party to the decree, that is, the stranger who purchases the property from the decree holder. Stop. The court in Chinamal laid down the test to ascertain whether the stranger purchaser would be entitled to retain the property by the principle of restitution. Stop. The court said that the true question in each case, therefore, is whether the stranger auction purchaser knew of the pending litigation about the decree under execution. Stop. If the evidence indicates that he had no such knowledge, he would be entitled to retain the property purchased, being a bona fide purchaser, and his title to the property remains unaffected by subsequent reversal of the decree. Stop. The court by all means should protect this his purchase. Stop. But if it is shown by evidence that he was aware of the pending appeal against the decree when he purchased the property, it would be inappropriate to term him as a bona fide purchaser. Stop. In such a case, the court also cannot assume that he was a bona fide or innocent purchaser for giving him protection against restitution. Stop. No assumption could be made contrary to the facts and circumstances of the case, and any such assumption would be wrong and uncalled for. The court answered in Chinamal. Stop. In the present case, the stranger purchasers protested against the applicability of the principle of restitution. Stop. Despite having knowledge of the pending challenge to the decree, he purchased the suit property from the decree holder. Stop. The court ultimately held that the auction purchasers cannot object to the restitution of property to the judgment debtors on the reversal of the decree. Stop.